Some analysis now on the matter. I'm joined by legal expert Advocate Romeo Nthambeleni. Advocate, good to have you with us tonight. Another postponement yet again in a matter one would say has been ongoing for decades. Is there a limit as to how many times you can postpone a matter and how far out you can postpone a matter and under what circumstances, what conditions?
Yeah, thank you, Thabo. Good evening to you and the viewers. Yes, that question is correct to say that the proceedings cannot be just drawn out till eternity. And that determination of the time frames is set out by the judge following the rules of court. And hence you have seen that there were time frames that were set out in terms of compliance by both parties in terms of their response in order for the trial to actually proceed in earnest.
The question of fitness to stand trial, I mean, at what point does the judge say the trial will continue without former President Jacob Zuma being present?
Yeah, look, that is the big elephant in the room, Thabo, in these proceedings, because naturally in criminal proceedings and criminal trials, the provisions of the Criminal Procedures Act read with the Constitution actually say that you cannot proceed with a criminal trial in the absence of the accused person. Only in exceptional circumstances you can conduct a trial in the absence of the accused person, where the accused person himself is making the trial proceedings unbearable, or in the circumstances where the accused person is sick and cannot be able to make it in court. So hence it is important to make a determination as to what is the fitness of the former president to stand trial. And as you can see, that this determination is yet to be made, because unfortunately you don't take the former president as you have found him, because now he was granted parole in a different matter which is not before the court, but this is a completely different matter that is standing trial for. So the judges indicated that they are going to give the opportunity also to the NPA and their team to be able to send him again for assessment to make a proper determination on his fitness to stand trial. So
let me understand you clearly. What you're saying, the question of medical parole does not come into play here. Whether or not the Commission of Correctional Services saw it fit to grant the former president medical parole, the courts still want to undergo their own processes.
Indeed, those are two separate issues altogether. In a different matter that is not before the court, he has been granted medical parole, and the matter that is before court, the court still have to make a determination on his fitness to stand trial. The interview that was done yesterday, relating to his release, doesn't help his case any further, because in that interview it was indicated that the person who was making the assessment overruled the medical report that indicated that his condition is stable. So as you can already see, so it means that there must be an independent assessment by the doctors of the NPA to make a determination on whether he will be able to stand trial, because this is a big deal. In a criminal trial, you have to be present in your own trial, and this is what his legal team was also arguing in relation to the postponement which was granted in their favor previously, to say they don't want a virtual hearing, they want a real court experience where he is present in court.
Is that a reason for, any justification whatsoever for the National Prosecuting Authority to doubt the bona fides of the military doctors?
It's a tough question. It depends on where you are actually sitting and who was actually doing the assessment. So I don't think that any doctor's report can be actually doubted, because the doctors actually have an oath to actually serve in honesty and in truth. So, but if there is a doubting and second guessing, perhaps maybe there are issues that are happening behind the scenes that we are not aware of.
Yeah, I say that because, you might find that, for example, former President Jacob Zuma's legal team or those in his quarters might feel like, well, there's really no reason for a second opinion. I mean, there's a report, it's there, tells you what the problem is, why a need for a second opinion. In fact, there was even some reporting that says he had actually refused the NPA doctors to run tests on him.
Yes, I remember hearing those allegations, and unless they're actually proven that he they refused. We are really not sure because, if the refusal cannot be done because it's an order of court for him to be subjected, to those tests. So if it's an order of court, a refusal of that order is against, again, contempt of court. So I don't think that, he will want to actually go back there. So basically, it's always better to seek different, opinions when you're actually dealing with a person, because sometimes doctors don't necessarily see things the very same way, as in other professionals as well.
Yeah. Now, if indeed the report received by the NPA seems to suggest the same thing that we are hearing in the interview with the Correctional Services Commissioner yesterday, that the Medical Parole Board found that he was stable. Does stable mean fit to stand trial?
Yeah, it's a good question, Thabo, that you're asking. It's stable, can be interpreted to mean that he's fit to stand trial, because in fitness to stand trial, you must be able to participate, with your lawyers and exchange information in real time. So that will be made by, the determination will be made by the doctors and obviously by the prosecutorial team, in consultation with the court and the doctors. And after evaluation and the maybe assessment that is been made, then it can be made a determination of whether really he is fit to be able to stand trial, because fit to stand trial means the appreciation of the proceedings and what is actually happening. So depending on the nature of the sickness, such determination can be made by both teams and also by the court.
Yeah. In your previous analysis, talking to my colleague, I heard you say on this matter of fitness to hold office, we must also acknowledge the fact that this is a former president, but not only that, he's also an elderly former president of the country. And therefore, maybe to an extent, there is a treatment of a special kind to this matter. Is the former president being extended some level of leniency in how this matter is being handled?
Definitely, there's no doubt about that, because if it was a case that was being done ordinarily in the ordinary course, it wouldn't have been expedited in the matter that was expedited. So ordinarily, that is what we are actually seeing in terms of how the proceedings are actually unfolding, because in the normal course of events, the court will not allow you such a kind of a case. So you can see that here we are really dealing with a special case and with different and special circumstances, and that's why we are finding what is unfolding in the pattern that is actually unfolding.
Yeah, and of course, whether the president remains in hospital or he is released to be at home with this particular matter that has been undisclosed at this particular point, how do then the courts interpret that?
Yeah, like I said, that these are two different matters. On the other hand, he has been given medical parole based on the reasons that were correctly, as you have indicated, were not correctly disclosed to us as to what is the reasons and the conditions that are set out in relation to that release on medical parole. So the court in this criminal matter must make a determination and its own assessment to actually determine whether he is actually fit to stand trial, and if he is fit to stand trial with this legal representative, how will the trial proceedings unfold? Because previously they insisted that there can never be a virtual trial because that is actually going to affect his rights. So he must be brought to court, and and depending on his condition, like you've correctly said out, if he's unwell, you're going to wheel him there in a bed, on a stretcher for him to attend trial. I don't think that is actually going to happen. So that determination ought to have been be made, and then we can be able to see what will unfold after the medical reports by two different doctors have been sent to the court and has been assessed to make a determination. But I believe the court will arrive at a decision as to what will be suitable under the circumstances.
Legal expert, Advocate Romeo Nthambeleni, I appreciate your time. Thanks for coming through tonight on In Focus.